it correctly, Raffaella. Is that correct?
Yes, thank you. Thank you, Vikram.
Good.
Good day all.
But the thing is that, look, what I'll do is, before getting you in, let me just put out what we are doing, so that at least there's an introduction to the symposium. Mediation legislation: how, what, when, where, which, who, why, and any other questions that you have, Raffaella, you can add to that. So now it says 50 speakers, 30 countries. Now there are 50 plus speakers from 30 plus countries. So that's how it is. So this is what you're doing. Raffaella is going to, of course, tell us about herself. So Raffaella, it's all about you.
Okay, thank you. Thank you very much, Vikram. Thank you for inviting me to the symposium. It's a great initiative, and it is very useful and important to talk about different legislation, about mediation. I've followed your symposium. I tried to watch your videos, the other speakers, very interesting and different approaches to the mediation culture and legislation. Here we are talking about Italian legislation. Before starting any discussion about the legislation, I have to tell you that we are right at this moment, we're undergoing a very strong changes in the mediation legislation, a reform just enacted, and the reform, the legislation changes the culture and approach of mediation dramatically, I would say, because I don't know, I think you might have heard, or many of the international mediators and community have heard about the Italian model, because Italy was one of the first, at least European state to introduce mandatory mediation legislation back to 2010. So we introduced mandatory mediation legislation, the legislation in order to comply with the European directive. Actually, the European directive asked member states to promote mediation and ADR as a mechanism to resolve and settle disputes, especially cross-border disputes. That was the intention of the directive. So in 2010, the Italian legislation introduced the Mediation Act, and the legislator chose to introduce an obligation for a list of subject matters as a precondition to filing a lawsuit. You know, please interrupt me.
I am going to interrupt you, Raffaella. We have to know about you first. A little introduction about you, mediation legislation.
Oh, sorry, I forgot all about me. Nothing interesting about me, because I am a lawyer, still practicing law. But I decided in 2008 to study mediation along with arbitration, international mediation and arbitration. So even before the Italian law was enacted, I got interested and passionate with mediation. And in 2012, I founded a company, which is a mediation center, because in Italy, mediation is administered only. So we have mediation centers dealing with and managing mediation cases. There isn't any mediation sole practitioners at the moment, apart from family mediation, which is different. We talk about civil and commercial mediation. I am a trainer as well. I train professionals, accredited Italian mediators. I also teach mediation at university in Italy and abroad. I teach mediation and negotiation, and with students it's fantastic to experience the through that the role plays, the practice of mediation. And I also am an experienced judge, evaluator of mediation competition, international mediation competition at ICC. I was one of the judges of the final this year. It was very exciting. And I think that as mediators, we all have to contribute to spread the word of the mediation culture, to contribute to the peace building culture and approach as a method to solve disputes at any level. Because in my opinion, mediation is a very powerful skill that can be, and procedure that can be applied in so many environments, subject matters, workplace, judicial cases, peer mediation in schools, as a method to prevent, to conflict, to manage conflict at any level. Where there are two persons, there are two different point of views. So understanding the peaceful approach, the collaborative approach at any level, at any age, is very important to change the society in a better society, maybe a peaceful world as an aspiration at least.
Which is what I'm trying to do, my little bit on that, and creating this world mediation circle and mediation circles in community schools. Let's see how it goes. Let's see, Raffaella, how much she works with me to do that in Italy. Let's see how that happens. So we'll take that forward. So yes, yeah. So about the legislation, you were talking about the legislation. I cut you off there.
Okay, so I know there's a big challenge and debate about mandatory mediation, the obligation to try to mediate a case. It's also an ethical issue, but it's also a question of legislation, which is the best legislation. Italian legislator made a very strong decision in order to change the culture, the judicial culture as well, the culture of lawyers, the culture of judges, and also parties. Because before 2010, we had conciliation as a method of solving disputes, but the practice was actually, we would say, none. Very so little. So in 2010, the legislation introduced the obligation to try to mediate cases before filing the lawsuit in court. So the decree 28, number 28, was enacted in 2010 and introduced this obligation to try in several subject matters, like I can talk about some of them. I'll tell you about the list of these subject matters, like condominiums, real estate, property divisions, hereditary successions, family agreements, leases, loans, company rentals, damages arising from malpractice, defamation via press or other means of advertising, insurance, banking, and financial contracts. So a significant amount of cases, which represented actually just a small percentage of the entire caseload of the Italian jurisdiction. Recently, as I told you to begin with, the new Italian legislation, the reform, introduced additional subject matters. This is very significant also from the point of the results obtained during the last 10 years, 13 actually, because although the percentage of cases settled in mediation is still not so big, the culture and the approach to the method has changed and has proven to work to to work well. So the legislator introduced additional subject matter for the mandatory obligation precondition before actually filing a lawsuit. And I've added other matters and other cases like joint venture agreements, syndicates, franchising contracts, contracts for services, partnership company, subcontracting. So as you see, the mandatory mediation has widened regarding the list of subject matter, which means that the chance for the mediation approach to be applied before actually filing the lawsuit will increase. It's going to increase. So we are all as mediators, of course, and also as lawyers. I'm a practicing lawyer. We all welcome the additional subject matters introduced by the law, although there are downsides, of course, connected to the new legislation, depending also from the point of view you are looking at it. As a mediator, I'm happy to see that the obligation to try to settle is now increased, because I've seen, after 10 years of practice in mediation, I've seen lawyers changing the approach. Why I talk about lawyers a lot? Because we have a very peculiar obligation regarding the participation of lawyers, which is mandatory for these subject matters at least. So lawyers are always sitting at the mediation table.
That's sad. I'm saying that's sad. Okay, then I'm a lawyer myself, but I'm just commenting on it. Please.
I've been talking about this mandatory obligation a lot with loads of mediators from all over the world. And I remember, like when I was at ICC back to 2016, the other mediators were so disgusted, like talking about mandatory mediation, because mediation is voluntary. I do agree with that. But as Professor De Palo talks about in many of his articles and books, and in his I don't know if you've heard about his project about the Sleeping Beauty, talking about mediation as a sleeping beauty waiting for his Prince Charles. Who's the Prince Charles? He says that he is the Prince Charles, but of course when he jokes about it, but one of the Prince Charles is supposed to be the legislator, in order to give this gentle nudge, you know, to push a little bit that the culture of mediation, at least to have lawyers to get to know what mediation is. Because if you don't know what mediation is, you cannot appreciate that the potential and the powerful tool you can take advantage of using a mediator. So if it's just voluntary, as it was in Italy before 2010, I'm afraid that mediation would not spread. And I've heard that also, for example, England, Great Britain is introducing mandatory mediation for small claims up to £10,000, I think, at least for small cases. And if we talk about mandatory mediation as a mitigated obligation, I think we can all accept this small burden, because I don't want to talk about Italian fees, mediation fees, because they are pretty low fees, right? there's an additional fee in case of success of mediation, which is another issue I learned. It's an ethical issue. Are you, as a mediator, allowed, and is it ethical? Is it right to charge people because of success? So if an agreement is reached. I was at ICC this year, we were discussing this topic, and I saw some people looking at me from other jurisdictions. It's a felony in our jurisdiction to accept money because of success, because of the agreement, because the mediation was successful and the parties signed an agreement. And I was like, oh, I understand the point, but I'm trying also to make with you some afterthought, or at least try to reflect about it. Of course, as a mediator, being an impartial, independent, and neutral professional, I shouldn't have, and I actually don't have any interest in the parties for reaching an agreement. Well, I'm not interested in that as long as I'm not interested in the terms of condition, at least as long as the parties are reaching an agreement suitable to their interests. So I'm not suggesting any terms and conditions. I'm not drafting the agreements as a mediator. They have lawyers there. Very important. So their rights are safeguarded, talking about rights, the guarantees of law. I'm a lawyer, but when I'm a mediator, of course, I don't practice law, and I don't help parties regarding their rights, their civil rights. I mean, if one party wants to waive some rights, I cannot say, look, you are waiving your, for example, a statutory period which is expired. I cannot suggest to the parties, look, you are waiving your rights, because they have a lawyer there. So they know they're protected. So if you look at this peculiar provision we have, maybe it is not so bad, because I heard some mediators saying we are independent, we are neutral, we are distant, we are not interested. Do you think, is it okay to say that a mediator is not interested? We too are interested in the parties to talk to each other, to have a collaborative approach, to try to settle.
That's why to debate this, I had a symposium on neutrality and mediation. So please, if you find time, watch some of the sessions. We have to debate that, just to see people, of course, say that we are neutral and all. We should not just use words so casually. There's lots behind it. So we debated that. In a sense, we discussed it. So please have a look at that, because that is important in relation to what you're saying. Yeah.
Oh, okay. Then, in addition to it, we in Italy also regulated the use of online mediation, which is very important after the pandemic, because the online mediation spreaded during and right after the pandemic. Before it, usually mediation was just in presence before the pandemic. Now it increased a lot, and so the legislation rules also the use of online mediation, which platforms, how to sign the agreements, the guarantees of confidentiality, how the parties can sign the agreement, and also the record, because in Italy we have this final record of the mediation session, which is very important because of the relationship with the jurisdiction, so with the trial. because the obligation to try mediation before actually filing a lawsuit is very important once the parties do not reach an agreement. So in that case, they have to prove to the judge that they have tried, so that they complied, they performed their obligation to sit at the mediation table. Because in case of failure, there are sanctions, and the most important sanction is that the request filed in court can be rejected by the judge if the mediation obligation is not fulfilled. So as you see, it is very important for the parties to try to mediate. Before the reform, we had this preliminary session, just so the parties could fulfill their obligation to try mediation, just showing up to this preliminary session. Now with the reform, the parties have to actually try to mediate the case. So that the final report of the session is a written report, which will end up in court if the parties don't reach the agreement. Is very important because there are sanctions.
Yeah, what I'm trying to understand is that when they say that they should try and mediate, so now who will gauge whether they actually tried? Is this going to be gauged by the mediator, or is it going to be gauged by the other side, or is it going to be gauged by the judge? How does that happen? Because it's a very sad part and serious part of how mediation is now progressing in places. So this is, I think, a very, I'm saying again, sad. I'll keep saying sad because who is anyone? Yeah.
I'll give you an example, a practical example. Say, for example, as a lawyer, I have a client who wants to file a lawsuit against his siblings because they have the inheritance. He or she wants to share his piece of inheritance, and so there is a dispute between the siblings. So my clients comes to me and say, look, I wanna sue my brothers, and sisters, because we don't find a way to divide up our assets, and being a subject matter for which the law provides mediation, I make my client aware of this obligation and say, look, we need to file a mediation request before a mediation center. So we file a written request to a mediation center for the disputes claim, writing down our claim and asking the mediation center to convene the other party at the table. So the mediation center sets up a date, appoint a mediator, and set a date. At the date of the hearing, both parties must show up. So the requesting party and the defendant and the responding party, because the obligation is an obligation on both parties. If the requesting party don't comply with this obligation, doesn't perform this obligation, the judge in court will check on this, and if the judge finds out that the mediation request hasn't been filed, gives the party the chance to file it during the trial, okay? And sets a hearing within 6 months. At the following hearing, if the party still hasn't showed in the mediation center or filed a request, the lawsuit will be rejected, the request.
So basically, it's only up to the point of coming to that mediation, just to come and sit in it. Is it only limited to that, or anything beyond that? Because there are jurisdictions where things are going into whether you went into it in good faith or not, whether you were.
Yes,
So those are the issues which you have to tell us about.
yeah. The Italian legislation expressly asked the parties to try to mediate in good faith.
Yeah, that's going to be a big. I mean, finally, the judiciary wants a say in everything now. So, by the way, I mean, this is okay. These are serious things, but
It's a bit a lot because who's going to evaluate if the
exactly.
parties have been negotiated and mediated in good
So
faith?
judiciary is taken over. They've taken over. So because let's start with the first thing. Mandatory and mediation don't go together. So they put it there. Then on top of that, force you to go and sit with someone. Okay, we'll force you to do that. On the other end, if we feel that when you were sitting together, you did not have the right attitude, we will decide whether we should impose a cost on you. And this will go into absurd things, Raffaella. We've opened a door to, I mean, in a way, harass people, it seems. But what to do? Judiciary is judiciary. That's why I had a whole symposium on colonization, decolonization, and mediation, because the colonized mindset and the way judiciary is treated, I think that needs to be questioned at some stage in every jurisdiction. I think that's a big issue. But the other things that I wanted, just one thing I wanted to, two things are really actually. One is, what was your law on conciliation that you spoke about? And the other thing on the aspect of an individual wanting to practice as an independent mediator and not connected with the centers. Is that possible or not? Both these things a little bit.
No, mediation is only administered, is only institutional. Mediation, only accredited mediators can practice civil and commercial mediation.
That's so sad. Again, do you think that's sad?
I don't agree with that because the mediation, I don't agree, but I live in Italy. That I don't agree with that. But I mean, the point is that if you go to a sole practitioner not accredited by the Minister of Justice, that's not mediation under the decree. So you cannot take advantage of the for example, of the if you reach the agreement, an agreement signed before an accredited mediator in a mediation center is immediately as the same force as a judgment.
I understand. Yeah, I
So it's
understand. Well, yeah,
enforceable, you
yeah,
know.
yeah. It's good. A lot of
Cannot
countries are doing that. Yeah.
and is for good. I mean, nobody can question the agreement, and none of the parties can appeal, can sue the other parties saying the agreement is not valid.
No, well, Rafaela, my question really actually is, who makes mediators? For me, only people in dispute can make a mediator. They can make anyone a mediator because it's someone that they trust. Now, again, this whole concept of party self-determination is kind of finished. You limited the people who you go to. We've actually pushed them into a process saying that you have to go into the process. So there's no concept of party self-determination, as I can see. On top of that, the way I put it out is, you have an inefficient judiciary who can't handle the work they have. So they created this thing about mandatory mediation to push people into mediation because they cannot handle all the cases which are in their court. And when they push them there, now imagine you push them there, you limit the people whom they can go to. And in that mediation itself, people have to settle or are settling because we don't want to go back to that inefficient judiciary because they take too long and it costs too much. So we'll settle. So that inefficient judiciary has actually influenced that mediation itself. So party self-determination is zero. That's what I can understand from it.
Well, you know, the big difference is made by the presence and the legal assistance of lawyers. There's a big, massive difference there. That's why I think that we need to think about the entire system. So mandatory mediation with mandatory assistance of a lawyer, the enforceability of mediation, a written mediation agreement. So we need to consider all the different requirements to understand that there's still freedom.
Man, where is the freedom, Raffaella?
Free.
Where is it? Look, I'll tell you what you do is have a look, because of course maybe Jimena will be coming in, her session starts, but have a look at our law. Have a look at our law. I put it in the post, the link to the law. Have a look at it. All we have to discuss on the 19th, we have a workshop. We'll discuss that law and the other things that come up during the symposium to have a look at whether that kind of a structure, where are the issues in that structure that the people in dispute can appoint whoever they want. Whoever they want. It's someone that they trust. We cannot create trust in someone for them. They trust someone. If they want to go to an institution, they want to go to anywhere, it's their choice. It's their choice. It's a choice matter, not a forced matter. So we'll have a look at that. The aspect of what all you need to legislate. Because look, for one is what is connected to the court. And I think people are a little too obsessed with what is in the court. What about all that which is not in the court? Aren't we wanting to hit right at the root and try to get mediation happening right at the root before it reaches court, much before it reaches court? So if you have to create that culture, what is the legislation we should create to create that culture? So that right at the first stage, people can actually go for mediation and they can, like I said, appoint whoever. I have, of course, pointed out in the sessions also that confidentiality to be protected, it should be without prejudice, and the mediator should not be called as a witness. These things, legislation should take care of. These are what I feel they should take care of. Beyond that, it has to be their process. The moment we do want to get into that process in any way, I think that is where we are actually finishing off the whole concept of mediation. So we'll have a discussion. And I wanted to tell you this is because Jimena might come in, then we'll have to start her session. She is a little, so we can go on up till she comes. So yes, so a little bit on that conciliation law that you were saying, that you had the law on conciliation, then that didn't work out too well. Do you want to tell us about that law?
The conciliation law?
Yeah.
Different from mediation, you mean?
What was it? You said that there was a law on conciliation earlier, but it was not very, wasn't used too much.
Well, the conciliation law was actually, there wasn't a conciliation law. The civil proceedings talked about conciliation.
Okay.
But judges, and a judge can still try to make conciliation. It's up to the judges. They can make a proposal to the parties, still connected to the court, to the civil proceedings. When we talk about conciliation, or within, the arbitration system before, so as a clause in the contract, but not mandatory. It is different from mediation nowadays.
But tell me, Raffaella, now, what is the perception of mediation by people? Because, how do they look at it?
People don't know much about mediation. The previous law and the reform law talks about advertising mediation too. It is very important for people to know, and lawyers as an obligation, also in the subject matters, in particular when we talk about mandatory subject matters mediation. Okay, but as lawyers, we have an obligation, an ethical obligation to inform the parties that they can try a different path before actually filing a lawsuit. So it is very up to lawyers also to make people informed. The government also, I remember they did a campaign, it was on TVs about mediation. It was so bad. Even more confusing because it's a bit technical. So maybe because I'm a lawyer, my firmament is a bit concentrated much on, of course, on disputes, on lawsuits, but we try as lawyers, as problem solvers, to negotiate first with the other parties, and then if the negotiation doesn't work, so we can try mediation. So it's really up to judges, lawyers, universities, schools, maybe also municipality. So it's really up to all of us to make people aware of mediation. Another very important important requirements of the new legislation, Mediation Act. The Mediation Act provides for mandatory personal participation of parties, because before, especially to the begin with, lawyers came to the mediation table with a power of attorney and parties don't show up. Now, the legislation makes it compulsory for the parties to show up and sit at the table, which is very important and makes a big difference.
Absolutely. Yeah, that's the whole concept of mediation. Yeah. But tell me, Raffaella, now let's just look at it. Okay, there is legislation. For a moment, let's put it aside. From your perspective, for promotion and development of mediation, what should the legislation look like?
From my point of view?
Yes, totally. You're the legislator. The interesting, but one before that, in terms of your this law, there is a certain requirement in relation to certification and accreditation of mediators. There's something there that who will train them and who will certify them. Is there something in the law?
Yes, yeah. We all talk a lot about mediators, professionalism, quality of skills, and the legislation is provides for an obligation for mediators to attend a course, 50-hour course, which is not a lot, 50-hour course, but if you're a lawyer, you only need 18 hours course to be accredited through a mediation center. There's a list that the Italian Minister of Justice, there's a list. So we are all accredited. And there's an obligation to also attend courses every 2 years, 18-hour courses to adjourn your skills and professionalism if you want to be and remain accredited in the list.
Because I'm just thinking that the way, I think there is some misunderstanding of what mediation is. Like I said, it is someone you bring in because you trust the person. I'm just thinking the legislators legislate on certification of mediators, which is a person-to-person interaction. It's their process. But are legislators themselves required to have some certification or training to be legislators, to be in politics or to be elected by someone? Is there any qualification required, any certification required, any kind of training required in Italy? Because India, there's nothing. You can be.
I do agree with. I think so. I think so. I mean, there are psychologists, engineers, surveyors. It's not only about, most of mediators in Italy are lawyers, but that the minimum requirement is to have a master, not necessarily a master of law, engineer, psychology, but you need a minimum, and then the participation to a course.
Are we also going to now talk to the legislators that what certification or training or qualification do you have to actually make law for people and tell them to have some certification? I just find that a little amusing because, I mean, first of all, I say a lot of other things I don't want to even talk about. I'm going to talk about mediators themselves. I mean, that is an area where what will you really certify? What aspect do you understand of that process? How much do we understand? Because I've had discussions on various parts of it, but one very fundamental thing which I keep talking about, a lot of people might not think of that as an important aspect of mediation, but I talk about heart, soul, spirituality, and that having a relationship in mediation, which for me, how do you certify or gauge or have any training on that? It is somewhat what a person is, what Raffaella is as a person. I cannot create in a training. Her life has created you as what you are. And that is what you bring into a mediation, and that's what connects you with the people. I think the process, again, I think everything we should legislate seems to be how things go, and again over legislate sometimes. But the fact, I think everything in not to be legislated, which I give an example, tomorrow you'll say mothers have to be qualified, trained, certified by us, then you can be a mother. You'll start doing all the kind of absurd things because two people bring in a third person into their room, into a house, wherever, and say, please help us resolve this. No, you can't sit with this person. The government doesn't allow you to sit with this person to resolve it. You only can sit with these people who are in that panel in this particular institution. This person is an inferior quality person. So you've created a class distinction. This is a certified person, that person is a mediator. Someone who's helping people or actually resolving things is not a mediator. You're a second class citizen. Again, this comes from the colonial mindset that you are savages. The person that I tell you is the person you can sit with. You don't know who you can sit with. So what we are trying to really tell people is you don't know who you can trust. We will tell you who you can trust. So I think it's going into very absurd and more absurd areas, because the point, the starting foundation by itself, I think there is something fundamentally wrong in the way it's structured. And I don't know, I feel definitely the people who have taken it forward. And I think Leonardo the Corso has done a lot of work there. And at the same time, he also has an institution also so is there a conflict of interest there when he promotes mandatory mediation on one end and actually has an institution? I don't know how that connection works, but I'm just thinking from now, when you said that you have to be part of an institution. So I think that is where I think a little conflict of interest aspect might also be. I'm just thinking from that perspective. No, but it's not. I mean, these are lots of questions and I can't expect you to answer all of them, not at all. But again, I'll come back to the basics. Now you want to promote and develop mediation in Italy. What would that law look like for you? What would you really want in that law?
But in my opinion, the most powerful mediation cases are the one referred by court. You know, Vikram, in Italy, we have a very heavy caseload. It is very important for the Italian economy and also citizens, for everybody. If we want the justice, the system of justice to work, we need for the courts to be able to handle the number of cases. So mediation is a very important tool to support. Actually, we talk about an holistic system now, where mediation and jurisdiction are together to form a universe,
Which I think
part of the same system, to offer to people a solution to their requests, to their claims.
But definitely, don't you look at it from the other perspective? Look at it from the other side. Look at it that this is, like I said earlier, this is an inefficient institution. Now that inefficient institution wants, of course, the help of mediation to reduce its caseload. That's what they want. They want, in some way, something can help us to reduce the caseload.
Yeah, okay. Yeah,
perfect. That's their vested interest. It's a vested interest of theirs. Because it is the judiciary and they can work towards developing how they've been able to develop the law and everything. But Jimena's here, but we'll get her in. But the fact is that in the inefficient institutions work and the way they are not being able to work should not be a reason to connect a totally different process with the institution. I'm saying, instead of saying mandatory mediation, it should have been request. Judiciary, when it comes down and folds its hand and say, request, we are inefficient, we can't give you justice, we can only deny you justice, because justice delayed is justice denied. I'll keep going into it, but Jimena's here and Jimena won't have too much time. Jimena, how will we do this? So I'll tell you what, Raffaella, we'll have on 19th, please come to the workshop. Let's have an open discussion on what we want.
Yeah.
So one concluding remark, you have that 2 minutes to, please, I don't know, 2 minutes, maybe less than that, just to conclude, please.
Yeah, just to conclude, I know it's very difficult to understand the Italian system because it's very peculiar, but I can assure you that in 10 years, we've changed the culture a lot amongst lawyers and judges.
I'll tell you,
very skeptical against mediation. Nowadays, the culture has changed.
But I tell you, Raffaella, you think it's going to change. I have seen, at least in our country, 25 years it's been on the book. Mandatory mediation concept has been there. It doesn't work on the ground. in the judiciary, in the lawyers and everything. They keep talking about it. Point is we need the first instance where it develops a culture. It hasn't developed the culture because, like I said, you put a gun on someone's head and you say settle because that there is an inefficient judiciary on the other end. We don't want to go there. So, okay, let's just finish it off here. That's not really mediation. That's
Italians still fight, don't worry.
no, I'm telling you, Raffaella, I'm telling you, your mafia, your Italian mafia, which is of course quite. I mean, people speak about.
In Italy, lawyers still fight if they want to. You know, we love law. We come from the Roman law.
Yeah.
We do
This
love.
is another mafia, Raffaella. It's another mafia. I put a gun in your head, and your cost and time pass by. But we won't get to that. So thank you very much, Raffaella. Please, you can say hi to Jimena. Jimena is in Chile.
Hi.
But at some stage, Jimena, you'll have to, of course.
Hi, hi, Raffaella. Nice to meet you. Hello, Vikram.
Yes, we are just going to